What happens when a man who treats every room like his personal stage walks into the one place where the script is already locked, the microphone can be cut, and the audience doesn't clap? What happens when Donald Trump walks into a courtroom? This is not a normal hearing. This is not political theater. This is a controlled collision between personal power and institutional authority, and for the first time, the rules are not negotiable, the timing is not his, and the consequences are not optional. This is a courtroom where every word becomes evidence, and every violation becomes a record that cannot be spun, erased, or reframed. And it starts with something deceptively simple, a 30-second moment that most people would dismiss as noise, but it isn't noise, it's a signal. You guys are disgusting. You are the Nazi. You're chasing your pension. Shame on you. That voice is not just anger. That voice is accusation. That voice is a direct attack on law enforcement, on the very people who are supposed to enforce the law impartially. And then comes the line that changes everything. He works for you. He works for you at the Department of Justice. Now stop and think. What is being said here, and more importantly, what is not being said? What is being said is clear. A man allegedly tied to violence, allegedly shouting, "Kill him," at police officers during January 6th, is now connected to the system that is supposed to uphold justice. What is not being said is even more critical. What does it mean for the credibility of that system when accountability appears selective? Because this is where the narrative shifts from a single outburst to a systemic question. And that question lands directly inside a courtroom in New York under the authority of Juan Merchan. Inside that courtroom, there is no ambiguity about the rules. Judge Juan Merchan issued a gag order, specific, narrow, legally precise. Donald Trump is allowed to defend himself. Donald Trump is allowed to criticize the prosecution. Donald Trump is allowed to speak about the case. But there is one line he cannot cross. He cannot target individuals involved in the proceedings. Simple rule, clear boundary. And yet, what follows is not compliance. It's repetition. Violation 1, warning. Violation 2, another warning. Violation 3, 4, 5, until the pattern is no longer accidental. 9 separate findings of contempt. 9 separate confirmations that the court's authority was ignored. 9. Not one emotional slip, not one misinterpreted statement. 9 documented violations. And each one carries weight, not politically, but legally. Because in a courtroom, repetition is not just behavior, repetition is evidence. And here's the contradiction that defines this entire situation. Outside the courtroom, defiance builds momentum. Inside the courtroom, defiance builds a case. The same action that earns applause in a rally becomes a liability under oath. The same attack that fuels a political narrative becomes a violation of a judicial order. And that is the trap. Because Donald Trump is not just speaking to his supporters anymore, he is speaking into a record that now shows 9 violations, $9,000 in fines, and a judge who has already warned, clearly directly, that if this pattern continues, the next step is not another fine. The next step is jail. So the real question is no longer whether the line was crossed. The record already answered that. The real question is, how many more times can it be crossed before the system decides that words are no longer enough? And this is where the tone shifts, because we are no longer watching a political figure testing boundaries. We are watching a defendant building a legal record against himself in real time. Not speculation, not interpretation, a record. 9 contempt findings in the courtroom of Juan Merchan. 9 separate rulings that say the same thing in different language. The order was clear, the warning was given, and the violation still happened. 9 times where the court had to step in and say, this is not allowed, and yet it continues. And let's slow this down, because this is where most narratives try to blur the details. April timeline, gag order issued. Shortly after, first violation, followed by a fine. Then another violation, another fine. Then multiple violations stacked together, each one recorded, each one documented, each one escalating the tone from caution to frustration to something much closer to enforcement. Total fines, $9,000. Now ask yourself, does that number sound like punishment? Or does it sound like a warning that hasn't worked? Because in legal terms, fines are not the end of the process, they are the beginning of escalation. And when escalation fails to change behavior, the system doesn't stop, it moves forward. That's not opinion, that's how enforcement works. Now here's the contradiction that sits at the center of this entire case, and it's not subtle. On one side, Donald Trump is operating under a political logic. Defy the system, speak loudly, attack opponents, show strength, never concede ground. On the other side, the courtroom operates under legal logic. Follow the order, respect the boundary, comply with the ruling, or face consequences. These two systems do not overlap, they collide. And every time Trump chooses political performance over legal compliance, the result is not symbolic, it is measurable. One violation becomes 2, 2 becomes 5, 5 becomes 9. This is what evidence stacking looks like. Because each violation is not isolated, each violation strengthens the next enforcement step. And here's where the logic becomes unavoidable. If warnings don't work and fines don't work, what is left? The court already answered that question. Judge Juan Merchan didn't leave it vague. He didn't suggest it casually. He stated it directly. Continued violations could lead to incarceration. Not metaphorical, not political. Incarceration. Now look at the behavior after that warning. Did it stop? No. It continued. Posts kept going out. Statements kept targeting individuals. The same boundary crossed again. So now we are no longer talking about whether Trump understands the rule. We are talking about whether he is choosing to ignore it. And that distinction matters. Because in a courtroom, intent shapes consequence. If a defendant doesn't understand a rule, the court explains it. If a defendant repeatedly violates a rule after clear warnings, the court enforces it. And enforcement is not optional. This is the part that doesn't get enough attention. The judge is not reacting emotionally. The judge is following a sequence. Warning, penalty, escalation. That sequence exists to protect something bigger than any one case. It protects the integrity of the process itself. Because if a gag order can be ignored 9 times without consequence, then it is no longer a gag order. It becomes a suggestion. And courts do not operate on suggestions. They operate on authority. So now the situation is no longer about what Trump says next. It's about what the court does next. Because the pattern is already established, the record is already built, and the system, by its own rules, cannot stay where it is. And once you understand that the system cannot stay where it is, you start to see the next layer, because this is no longer just about fines or even about defiance. This is about enforcement power. Real enforcement power, not the kind that trends on social media, not the kind that fills a rally, but the kind that operates quietly and decisively inside a courtroom, where precedent, not popularity, decides what happens next. Go back to 1970. A case that most people have never heard of, but every judge understands, Illinois versus Allen. The ruling was simple, but its implications were absolute. If a defendant becomes disruptive, refuses to follow court orders, and undermines the integrity of the proceedings, the judge has the authority to remove that defendant from the courtroom and continue the trial without them. Read that again slowly. Remove the defendant, continue the trial. No exception for status, no exception for influence, no exception for being a former president. And that is the legal architecture now sitting quietly behind everything we are watching. Because what looks like a series of isolated violations is actually moving step by step toward a threshold that the Supreme Court already defined. And once that threshold is crossed, the decision is no longer symbolic. It becomes operational. Now layer that onto the present moment. Donald Trump has already accumulated 9 contempt findings. He has already been fined. He has already been warned explicitly that jail time is on the table. So the question is no longer hypothetical. The question is procedural. What happens when the next violation occurs? Because under Illinois versus Allen, the judge does not need to invent a new solution. The solution already exists, and it does not ask for permission. It enforces compliance. But here's where the story turns from legal structure to human behavior. Because inside that courtroom, something else is happening, something that doesn't show up in official filings, but shows up in every report from journalists sitting just a few feet away. They describe a pattern. At the start of proceedings, Trump appears relaxed, even dismissive, leaning back, scanning the room, projecting the same confidence he brings to rallies and press conferences. But then the evidence starts to land, and the shift is visible. Posture tightens, whispers with attorneys become urgent, eye contact disappears, focus drops to the table. This is not interpretation, this is observation. Because for the first time, the environment is not responsive to him. There is no crowd to react, there is no platform to dominate. There is no narrative he can redirect in real time. There is only evidence, and evidence does not negotiate. Now place that against the version of Trump that exists outside the courtroom. Outside, defiance is currency. Attack the judge, gain attention. Challenge the system, gain support. Escalate the rhetoric, gain momentum. Inside, the same actions produce the opposite effect. attack the judge, violate the gag order, escalate rhetoric, add to the contempt record, refuse to adjust, move closer to enforcement. This is not a gray area. This is a direct inversion of cause and effect. And that inversion is the trap. Because politically he cannot afford to stop, but legally he cannot afford to continue. That is the collision point. And then there's the constitutional layer, the part no one has fully tested in modern American history. What happens when the defendant is not just any individual, but a former president? Can a court enforce contempt through detention? Can federal marshals physically remove him if necessary? Can the trial proceed without him if he refuses to comply? There is no modern precedent that answers these questions cleanly. But there is something more important than precedent. There is principle. The principle that no individual is above the law. Not in theory, in practice. And that principle is now being tested, not in speeches, not in headlines, but in a courtroom where each violation adds pressure, each warning narrows the path, and each decision brings the system closer to proving whether that principle actually holds. Because at some point, the system has to decide, are these rules real? Or are they optional when the defendant is powerful enough to ignore them? And this is where the story stops being procedural and becomes moral. Because at some point, a system is not judged by how it treats ordinary people. It is judged by how it handles the one person powerful enough to ignore it. Think about the image that has not happened yet, but is now sitting just one step away. A defendant, not a president. A courtroom, not a rally. An order, not a suggestion. And officers standing in place, not reacting to status, not reacting to influence, only reacting to one thing, a judge's command. That image matters because it answers a question the public has been asking for years without ever seeing a clear result. Does the law apply equally, or does it bend? Because right now we are watching a system being pushed to its limit. 9 contempt findings, 9 confirmed violations, 9 moments where the court said, stop. And the response was not compliance. It was continuation. That is not defiance in the abstract. That is defiance in the record. And records do not disappear. They accumulate until they force action. Now step outside the courtroom for a second and look at the broader contrast. A man allegedly connected to violence against police officers, someone accused of shouting, "Kill him," during January 6th, receives a pardon. At the same time, the system asks everyday law enforcement officers to trust that justice is being applied fairly, consistently, without bias. Do you see the tension? On one side, forgiveness at the highest level of power. On the other side, enforcement at the ground level of duty. And caught in between is the public, watching, measuring, deciding whether any of this still holds together. Because this is no longer about Donald Trump as an individual. This is about the credibility of the system that is supposed to hold him accountable. If the gag order can be violated 9 times without escalation, then it is not a rule. If contempt findings do not lead to enforcement, then they are not consequences. If warnings do not change behavior, then they are not warnings. They are theater. And the courtroom is the one place that cannot afford to become theater. So now we arrive at the moment that defines everything. Not a speech, not a post, not a headline, a decision. Will the system follow its own sequence? Warning, penalty, escalation. Or will it stop right here because the defendant is too powerful to confront? Because if it stops here, then every future defendant learns the same lesson. The rules are real until they aren't. And that's the moral line. Not left versus right, not party versus party, but power versus accountability. A courtroom is supposed to be the one place where those two forces are balanced, not negotiated, not adjusted, not influenced, balanced. And right now, that balance is under direct pressure, because one more violation is not just another number. It is the moment where the system either proves itself or exposes its limits. So ask yourself, honestly, directly, without filtering it through politics. If the same pattern, 9 violations, 9 warnings ignored, came from an ordinary defendant, would the system still hesitate? Or would enforcement already be in motion? And if the answer is different, then what does that say about the system itself? Because this is not about what has already happened. It is about what happens next. And whether the law, when finally tested at its highest level, still has the strength to act. If you want more breakdowns like this, clear, direct, and focused on what actually matters, hit like, drop your perspective in the comments, share this so more people understand what's really at stake, and subscribe. Because the story isn't over, and the next move won't be political.